Our final speaker today turned her family's tragedy into activism and advocacy. Elaine Pawlowski is a retired educator who became an advocate after the loss of her son Michael to a drug overdose. She currently lives in Daniel Island, South Carolina. She has written extensively about drug policy, recovery, and drug courts for the Huffington Post, and was an invited panelist in a forum on drug courts for the Open Society Institute.
Hello, and thank you for having me here to be able to share my story with you. As she says, I'm a retired educator, New York educator, and a mother, and I'm a first-time grandmother just this January. So, and it's a little girl, my first girl. I had 3 boys, so I'm like thrilled. But this is a story about my middle son. My son's lawyers recommended that he be placed in New York's drug treatment court after a driving with alcohol violation. This would change not only his life, but also my family's life forever. I've experienced drug treatment court as a supportive mom and have learned more since 2010 than I care to know about the stigma that substance use has on medicine, courts, drug policy, journalism, as well as advocacy. We didn't feel shame when my son was addressing his misuse of substances. We supported his efforts, and he openly talked about his ups and downs of his life. But drug treatment court and probation sent a new level of horror that we had never witnessed before. It's a dirty, dark secret that many families keep to themselves, and I think really I'm about the only one that's talking about it that I know of at this point. But not only are participants shamed in a public forum, which I think you saw some of in the little video short that they showed at the beginning of the conference, but family members are publicly humiliated and demeaned for their support of their own child, partner, or spouse. At times, it's not only the participants that are under the drug court supervision, but families as well. Private medical information is aired in public. Family shortcomings, as well as romantic relationships and breakups, are discussed. Hearsay or gossip is treated as truth. And sitting in court, I learned more about these participants' personal lives than I know about any of my friends. I watched children being taken away, mothers crying, and fathers in desperation. I watched police shackle participants in and out of court, and judges and lawyers berated their failures to stay clean, all under the disguise of medical treatment. It was for your own good and safety, the judge would say in our court, but how can prison ever be good for yourself when you have a medical issue? Judges and district attorneys take on reality show demeanor that the public views as acceptable. In fact, the National Association of Drug Court Professionals highlight a link to NBC's Dateline, which follows Scary Mary, the tough-talking judge in the Michigan drug court. The show shows like this think that they're showing a positive solution to a nationwide public health issue and do not realize that they, in turn, are allowing the stigma of those using substances to continue. When so-called news organizations such as NBC and others highlight this type of scare tactics as normal and acceptable, we need to ask ourselves what has happened to our society to allow this behavior from our court officials. The court antics and the atmospheres destroys all trust in the legal process, and this should not be an acceptable standard of any so-called innovative court. But we allow this type of tough love behavior because society views those with substance issues with contempt, and women, mothers, and pregnant women in particular who use drugs especially are distasteful to the public. We stigmatize them as unworthy, we stigmatize them as criminals, and that they deserve what they get. The public is led to believe that every participant in a drug treatment court should be more than thankful to have their chance to change their life and embrace treatment. They should not question, they should just obey. Although the federal government is supporting the use of medication-assisted therapy in the care of opiate treatment, it is not transferred to most state-run drug treatment courts. First, it is difficult to change what's been done for 20 years in these courts, and second, there simply are not enough state-supported treatment centers that have doctors to oversee or direct the use of the medication. In most drug treatment courts, the abstinent-only philosophy is imposed on each individual in drug treatment court, even those that do not have substance use issues. Participants may have been arrested for marijuana or other substances under our punitive drug laws, and in lieu of prison, they're receiving forced medical care that they do not need in order to stay out of prison. According to the National Institutes of Health Outcome Trajectory Study, it's estimated that 1/3 of those in drug treatment court do not have issues with drug or alcohol abuse, yet they are receiving mandatory treatment. These individuals were accepted into programs and used to boost the success rates, while others are denied care. If these state-approved programs did not take these court-appointed participants that did not even meet addiction criteria, these beds would be available to those that are really in need of care. Once my son entered drug treatment court, he had no control over his medical care. His doctors at that time wrote letters to the court about what they recommended for his treatment. It was ignored. Not only was his physician's treatment plan ignored, but so too was the drug treatment team's recommendations ignored. The DA at that time laughed at what her own team recommended. Since the judge agreed, my son was remanded to prison until they could find a place that the DA and the judge agreed upon. Granted, the DA and the judge have no medical degrees, yet they chose to ignore a respected physician's treatment plan, their own team's recommendation, and instead sent my son to prison until they could find a program that was acceptable to them. Why did this even happen? I have yet to find out. I petitioned for all the treatment notes, decisions, procedures, and court documents. As of this date, I have not received any treatment notes, and I am continually blocked by FOIL requests. Drug treatment court continues to operate behind closed doors. Judges, lawyers, and poorly educated counselors make medical decisions without medical degrees. It is becoming common practice for drug companies to solicit drug treatment court judges with new medications such as Vivitrol as much as physician offices, yet judges have no medical training to understand the rhetoric. Furthermore, doctors are liable for medical decisions and medications that they prescribe. Judges and treatment court members are not. They're left to practice medicine without any liability. The drug treatment contracts that are signed by participants are legally questionable and are not updated in medical standards of care or reviewed by experts for participation's protection. After bringing my son's contract to 2 new respected New York City attorneys, the response is similar, and I quote, "The defendant must accept the most severe authorized sentence, a prison sentence, and then puts himself at the utter mercy of these people for many years. He must waive the right to counsel, the right to attorney-client confidentiality, all rights to privacy, the right to seek bail on a new arrest and to oppose extradition, and the right to oppose a probation violation on the basis of mere hearsay, and he must even accept indefinite and ill-defined obligations such as to promote the program indefinitely. Participants have to make an agonizing decision to accept this program as an alternative to having their case adjudicated in the usual way and the risk that he would receive a conviction and jail or prison time." End quote. Many times these agonizing decisions to accept this drug court restrictions are simply money related. It costs money to go to court to defend yourself, and even if you're doing that, a plea is expected. Getting your day in court to truly be in court is no more. Lawyers will state that when you complete the program and graduate, your record will be expunged, but that's not the case either. Background checks will reveal that drug court was recommended and that you received addiction treatment, whether you actually are addicted or not. Employers may balk and refuse to hire. Insurance companies may report that you have used your max coverage and they increase your premiums, and state benefits and housing may be denied. The show in the public drug treatment courtroom is just that. It's a show. The teams are not held accountable for the legality of their contracts or their treatment recommendations. They're not held accountable for their mistakes. They're not held accountable for injuries or deaths under their watch, and neither are the injuries or the deaths regularly reported. My son's death is not reported anywhere in the court system. Each drug court operates so differently across the United States. That in over the 20 years of expanding drug courts, We really have no idea how many individuals or families have been hurt or what due process rights have been broken. The data simply is not there. Furthermore, participants of drug treatment court are placed on probation and do not have the same rights as others when it comes to getting emergency care for drugs or alcohol. New York's 911 Good Samaritan law, designed to save lives and encouraging people to call 911 during an overdose, doesn't offer those on probation or those in drug courts the same protection as others, even though the drug courts say that drug abuse can be a chronic and relapsing condition. I think here in Tennessee as well, you have a new naloxone law, and you also have a new 911 Good Samaritan law that just went into effect 2015. So this will probably apply to yours. I haven't read the law completely for Tennessee, but most of the laws across the United States so far do have limited protection, which would not include these mothers or my son or anyone else that's in a drug court. The capabilities of calling 911 without being arrested or at least charged. They and their families are left to fear the arrest, fend for themselves, and risk death from overdose. For me, all of these 911 laws that address this are cruel, stigmatizing, and discriminatory. They're placing these individuals in a life and death dilemma without access to naloxone, the opiate antidote, and emergency care during a possible drug poisoning. The U.S. government has marked substance abuse as an illness in need of medical support and promotes drug treatment court as the compassionate answer to illegal substance use. In actuality, it continues to treat these individuals as morally defective and in need of behavior modifications. Judges and lawyers are left to devise forced abstinent treatment that does not meet standards of care and are allowed to order participants into their own biased programs. Although there may be a recommended practices booklet for drug treatment courts, drug courts are not evaluated regularly to demand that procedures are followed or that education of team members are up to date. And I think in most states, it's very limited education to be a, quote, addiction counselor in drug treatment court. There's no oversight of medical recommendations, and advice from physicians are flatly ignored. The NADCP has a powerful hold over legislators and the addiction community, the criminal justice system. They continue to expand their poorly researched ideas and continue to parade celebrities in support of their programs. Since reviewing more and more of these contracts on my own, I now wonder if these celebrities do not have the choice to refuse either, as they too may be still under obligations from their own drug treatment court programs, and there's quite a few of them. Judges are left to do as they please as the public relation teams mislead the public, sensationalize the process, and sugarcoat the details with catchy phrases in public service announcements. Nowhere do they present an expert example of what should happen in the day-to-day proceedings of the drug court. They continue to support the Scary Mary philosophy as well as the judge that has been on this screen. My son never finished his court-mandated treatment program. There was no graduation, there's no final certificate. On July 4th, 2012, my son was found dead in his New York City East Side apartment. He was 29 years old. He was a vibrant, well-educated, working professional in New York City. He was being treated by his own physicians for his own issues. He recognized them. He had his own health care, and he was getting professional help. He was doing very well and was stable until that driving offense. We know the dilemma my son faced on the last day in July from the information that was left in the apartment. We know that he was in a crisis situation. We know that he could not present himself to the emergency room without breaking his probation. We know that the New York 911 Samaritan law wouldn't have protected him because he was involved in drug treatment court north of the city. On the day he died, he didn't go to the hospital as he practiced time and time again. He didn't call 911. No one made a call. He passed away in his home in Manhattan, even though he lived 1 block from Lenox Hill Hospital and his private physician. My son may be alive today if he did what he always did. He was taught to call 911 just like every kid. But because of the punitive drug laws and the stipulations of drug treatment court, he hesitated and questioned whether it was worth it. Call was not made. Furthermore, the police assumed he was just another investment banker that partied too much. Although the police had many questions, they waited for toxicology reports and no investigation has been done. The court sealed his record and everything is not counted. My son's home now. I visit him on the 29th step of the Morris Island Lighthouse in South Carolina, where I live now, and I continue to support the restoration in his memory. But there's no mother who should lose their son this way. There's more than 2,500 drug courts operating across the United States. We need to hold the judges responsible for their medical decisions made under their watch and hold drug treatment courts accountable for what they profess to do. They shouldn't be practicing medicine without a license and then blame the patient for their own death. Thank you.